All right, welcome everybody to our 17th webinar, Holmquist and Gardiner, focusing in real estate and business law, founded in 2008 by Hamilton Gardiner and myself, Imants Holmquist. We are obviously dedicated to performing services for our clients in the obvious, honest, ethical, and efficient manner. And it goes without saying, if you've worked with us, you understand one of our core values of constant urgency is something we focus on. Today, we're going to focus on the latest in eviction moratoria and its effects on both commercial and residential real estate, whether that be residential, commercial, multifamily, single family. Mike's going to move us through the slides, but I want to make sure everyone's aware we do have a monthly webinar. We've had 16 prior to this. Thank you for attending. If you want to look at the other ones, we have a YouTube channel at Holmquist and Gardiner PLLC, and we found that our clients have found this very informative, covering everything from commercial financing to multifamily sales and other topics that we regularly deal with, but are definitely a little out of the realm of just legal stuff. And so it's different market sectors with professionals with experience in the industry. And with that, Michael, our next slide. So today we've got our three partners, myself, Hamilton Gardiner, and Rob Maxwell. And we're going to start off talking about the specifics of where we're at right now with these eviction moratoria and what that means for specific kinds of properties, including residential, multifamily, and commercial. Then we're going to move into some do's and don'ts, and then we're going to cover some frequently asked questions. Also, as sort of a special guest today, and tied into, I guess, the do's and don'ts, we're going to have the City of Seattle candidate for City Attorney Ann Davison join us for just a few moments to tell us about her campaign and give everyone an opportunity to understand why, we think it's important that we support her. So with that, we're going to jump right in. We're going to bounce around a little bit today in light of our special guest attending, and which kind of makes it so that we adhere to her schedule as well. But with that, I'm going to turn it over to Hamilton to talk, Hamilton and Rob to talk specifically about some of the issues and the specifics of the residential eviction moratoria.
Thanks, Imants. Rob and I are going to kind of lead you through it. And we aren't going to cover everything in the moratoria because that would last about 6 hours, if not multiple days. So we're going to do our best to cover some of the highlights and some of the new things that we're seeing, specifically focusing on King County and Seattle, but also addressing the statewide moratoria. So, but the biggest piece of advice, if you leave here with anything, is that you need to check the local laws, being with the city and county and the state where your property is located before you proceed with anything. And I'll let Rob lead us off on the moratoria, and then I'm going to jump into a quick discussion on the eviction resolution program. Go ahead, Rob.
All right, thank you, Hamilton, and thank you, Imants. And yeah, so just to get it kind of running, we initially went into this whole COVID situation thinking that this was going to be a quick one and done, and now we're a year and a half down the road, and we consistently are getting the heads up that the laws and the current status of evictions and eviction moratorium and landlord, tenant, and commercial and residential are continuing to be extended, if not just outright extended. They're being extended in some shape or form. And so right now, I'm sure a lot of people out there have heard of the term, the eviction bridge. And so this was the most current statewide Governor Inslee order within Washington state, and applies to in the residential sector. And they're trying, and you could see with the legislation that's coming out there, they're trying to ease back into the system to get it back to where the laws were a little more steady, and there's not so much on the emergency side and people being reactive rather than proactive on these. And so right now, that current bridge, it was set to expire in September, and as everybody saw, it got extended to October 31st. The writing on the wall is we would assume that some form of it is going to be extended again. But under that, it's a very interesting program statewide, in the sense that they're implementing and putting out within county to county these different rental assistance programs, and they have a big aspect of how bridge, that eviction moratorium bridge is being facilitated and what you can and cannot do. So, but generally speaking, at this time, what the bridge is really doing is saying, you know, we're not going to look back for anything past August 1st, 2021 for rent from residential tenants. And so that's kind of, you can put that in your mind, is that that's the date that you kind of move forward. And if you are going to issue, or you have a tenant that's having problems with bills or anything going on that front, you are able to put forth a form of asking and requesting that the rent be paid at this time. But there's a process that you have to go through within the bridge moratorium. And we could be on this for hours at a time, just going through the details of that. But high level, before putting out any notice to pay or vacate for any tenant, you have to kind of go through county by county and see if they have a rental assistance program that's set up. And if that rental assistance program is set up, you have to facilitate basically a payment plan and structure with the tenant, for lack of a better word, to go through with this program in order to move forward with anything. So if a reasonable payment plan comes up, or if the rental assistance program is unable to help, there's options there, but you have to exhaust that prior to going through any action that could possibly lead to a removal of a tenant. And Hamilton, I know you had a little more details on that, on those programs.
Yeah, just two things I just want to highlight. Statewide, the bridge program goes through October 31st. You know, myself and Rob and Emons, we're expecting that to be extended. We don't know when, but if history is our guide, we expect that to be extended. In the city of Seattle, it goes through January 15th. Also, the writing in the wall is that's likely to be extended. If you want the good news, bad news is that the way that Rob and I are looking at it is that I can see that getting extended into, you know, for another 3 to 6 months. And then in the city of Seattle, there's the 6-month cooling off period, which then takes it into next winter, to the winter of 22, where you can't evict for 6 months. And then, so most likely I'm thinking and preparing our clients that at least evictions, from what we used to know, at least it's going to be likely going to be the spring of 23. That's horrible, but that's, and I hope that I'm wrong, but that's what I'm thinking may or may not happen. Anyways, where I wanted to go on the eviction resolution program, and then there's the rental assistance. Under the bridge program, Governor Inslee asked that both of these programs be set up county by county. If they weren't set up by the time this moratorium is ended, then you're free to proceed with the 14-day notice to pay or vacate. So theoretically, you can do this on November 1st if it's not set up in the county. And just keep in mind, as Rob mentioned, it's only for rent that if those programs are not set up, it's only for rent after August 1st. So, but if those programs are set up in the county where your building is located or your tenant is located, then you need to go through the eviction resolution program and assist those tenants before you can issue the 14-day notice. I'm going to walk you through the King County one quickly and what that looks like. I'm going to share my screen so you can see exactly what I'm talking about. The first step in the process is to provide the tenant with the appropriate notice. In King County, which this is, I'm just going to go through King County. This is the notice that you're required to provide to your tenants. You fill it out, you provide the information. So the tenants in here, the tenant's name, your name, if you have retained an attorney, or if you have an attorney, then you need to provide that attorney's name and their contact information. The tenant then has 14 days to respond to that notice. After they respond, they can say, I do want help, I don't want help, I want to negotiate. Once they get, and then if they do submit this form to the eviction resolution program, again, this is the pilot program in King County, then the program is going to then reach out to the tenant and coordinate for the landlord and the tenant to negotiate / mediate at the next available time. What does this mean? I actually don't know. This is just, again, a pilot program, and it hasn't been implemented yet because the bridge moratorium is still in place. So the next step is that the landlord and tenant can come to an agreement, or they can't. And then after that happens, then your certificate of completion is issued. So this is the notice that you would be given to your tenant that you complete and you submit it through the King County program. Here's the link, the Eviction Resolution Pilot Program. Again, it asks you for your contact information, building name, and to upload a copy of this ERPP notice that was given to the tenant. So you would upload it right here. You can also upload a suggested payment plan. Before, I won't go into too many details other than to show you what the reasonable repayment plan of unpayment rent looks like. This is in compliance with Senate Bill 5160 from earlier this year. Again, showing you the details of what is required and certifying the payment plan is in compliance with Senate Bill 5160. If we can provide you links to this, although I will tell you that they're also available if you go to the King County Dispute Resolution Center. That is where you can find links to all of these forms and where to submit through the program once the bridge is ended and the moratoria allows you to proceed with an eviction if you decide that that is the best course of action for you. One thing to note is that you're required to go through this process before, if these systems are set up, you are required to go through these processes before you issue the 14-day notice to pay or vacate and proceed with the eviction. So I just want to note that there's a few more hurdles that you have to go through before you get to the 14-day notice. Okay, I'm going to stop sharing my screen now, and Mike, if you can proceed with the rest of the slides. Okay, and there's two more items that I wanted to go through, particularly in the city of Seattle. Again, hot topics. The 6-month notice of rent increases. As many of you are aware, during the moratoria, the rent increases are not allowed. But a new law that was just passed recently in the city of Seattle requires that 180 days written notice be provided to tenants before you increase rent. That goes into effect here in about a week and a half. So we do have some clients that have been proactive and started issuing notices now. Also note that rent increases require 60 days statewide. So there's a whole list of new laws that you're going to have to look at and consider as you're considering increasing rent, evicting tenants, or updating leases. So that's one to take into account is rent increases, 6-month notices in the city of Seattle. Next slide. 2 slides before, sorry, I think you skipped over one. There it is. Okay, this is the other kind of hot topic slide, which is the City of Seattle Economic Displacement Relocation Assistance Program. We have until July 22 to determine what exactly this is going to look like. But in sum, if you as a landlord are going to increase your rent more than 10% and it's low income, then and the tenant then moves out because of your 10% or more increase, then it is going to be required for the landlord to pay 3 months of rental assistance to that tenant. So, again, we've got a little bit of time, but time has been moving fairly quickly. So if you're thinking about increasing rent and the rent increase is going to be more than 10%, you got to think when you're doing it, how you're doing it, and if it's a low-income renter, then they can receive this relocation assistance of 3 months rent. So just be aware of what notices that you're sending out, and talk to your attorneys. If you want to jump to that next commercial one, I think Emons is going to start on that piece.
Yeah, so the first thing here is this is the city of Seattle, not the state of Washington, unlike our slide here.
Correct.
State. So with regard to the existing commercial eviction moratoria, that's been extended now to January 15th. That's on all small businesses and nonprofits. Landlords cannot evict small businesses and nonprofit organizations for non-payment of rent. They're required to work out a payment plan or agreement. First question is, what's a small business? That's 50 employees or 50 people or less. Nonprofit is self-explanatory. If you have a question about this, again, best to talk to your attorney about it, determine whether you fall into this or not. There's also the provision that landlords cannot increase rent to a small business or nonprofit until COVID-19 is no longer an emergency. I think we'll be following along on when that date is. I think that's an interesting one that we'll learn more about. And then tenants must pay back rent within the year is kind of a condition on the payment agreement. And until this is resolved or until this moratoria is no longer, landlords cannot charge late fees, interest, or other charges. And we'll get into this in some of our frequently asked questions later on, how you would work with this and work within this to work with your commercial tenants. And if you are a commercial tenant, how to work with your landlord on making a resolution that works for everybody during what's obviously a difficult time. So with that, we're going to move now to some do's and don'ts. And I think we all agree that one thing we should all be doing is voting one way or the other. And to sort of, we will stay on this slide here, give our clients some insight into Ann Davison. We're lucky to have her on with us right now to just give us 5 minutes of her time, tell us about herself, and we'll leave Ann with that. Thank you, Ann, for joining us.
Thank you all for listening to me for a couple minutes on this quite rainy afternoon. I'm hearing the rain right here. So, and I do let everyone know I am working from home. So the dogs bark. That's just how we have to roll with it today. So thank you for taking a couple minutes. And Imans, thanks for having me on and introducing me. The election is next Tuesday, and it is really a very crucial race for city attorney. I've been living here in Seattle for 25 years, a lawyer for 17 of those. And I've been on the side similar to what is happening on this call today, which is on the preventative side, so that you are getting advice, legal advice from your lawyer. So we are preventing litigation from coming about as best as possible. And I think that's really an important part for the city attorney in regards to our civil side, which has been my background. I've also been an arbitrator and served a role like a judge does in private disputes. But the most important thing that might be on your conversation of late and in personal and business has been about public safety. And so it's really important to understand that I want to look at that for our city and its future in a way that is balanced, that makes sure that the government, our local government, is doing what it's supposed to do for business owners, for landlords, for families, for individuals, for people working in the city and living in our city, to get from point A to point B in a safe way. And that is about having reform and safety and not having them be mutually exclusive. And I think that is really the only way forward for our city, which is around 800,000 people. And it is significant. And just so you do know, my opponent does not want to prosecute most misdemeanors. And that is really what the city has going on a day-to-day basis that is starting to hinder business from operating, from people being able to just function. And it is taking over our thoughts and our energy and our time. And we need to make sure we are doing things in a way that is adequate and safe, acknowledging what we have had happen in the past, but in a way that is modernizing that approach. So we can move forward as a city. And that is really an important part. I'm proud to have the endorsements of former Democratic Governors Locke and Gregoire, as well as 30 retired judges from all the way from our state Supreme Court down to our Seattle Municipal Court. 30 judges have decided it is time to speak up, and that's an unprecedented move by them to show that within regards to the legal profession, I've been in practice and put forth the type of professionalism that we want at the city attorney's office, and to make sure there is a stark contrast between me and my opponent in that regard. Thank you for your time, and I don't want to take any more of it, but please come to our website, Neighbors for Ann, and send me any questions. And it is go time. We are doing the last direct to voter contact that we can. All hands on deck, everywhere, everyone, every day. I'm asking people to talk about this race. Because it really has practical impacts on our daily life here in the Seattle area.
Well, thank you so much for joining us, Ann, and we really appreciate your time in obviously the busiest part of the campaign. So thank you, and we wish you the best.
Thank you. Thank you, everyone.
And with that, Mike will be posting the link to Ann's website. And if you do nothing else, get out and vote. We're not necessarily advocating for, I know I personally will be voting for Ann. But it's important that we vote and show our, not just our civic duty, but that you care, because obviously there's things that are really important right now in Seattle. And the city attorney's office is an office that our firm works with very closely on a number of matters. So that's near and dear to our hearts. With that, let's move to Rob and some do's and don'ts in the area of this eviction and dealing with tenants and landlords. Rob?
Thank you. Yeah, and we just kind of want to, we were really going over, and you saw Hamilton talking about this, and it's big from the residential standpoint, because there are so many limitations on what a landlord and owner of property can do right now. And with all these limitations on how it's done, you just want to be proactive, and that's what we're talking about. We don't want to have a reactive system. We want to make sure that everybody out there is doing their utmost to understand the current laws that are out in place and implementing them to the best. Because what ends up happening, if you look at a prime example of this new law coming in for 180 days on a rental increase, if you don't do that notice properly 180 days prior, and for some reason it gets called out as it wasn't done proper, you're starting that whole process over. So it's another whole 180 days that you can factor into it. So you just want to be as proactive as possible. And during this time, the most critical thing is, in the past, we've had the great tenants. You hear a lot of clients will talk about, oh, he's a great tenant, never heard from him, paid the bills, the house was good, everything went hunky-dory, moved out on time, we moved on. And so there wasn't that much contact with tenants in the past. And what I've learned from this current pandemic and the eviction moratorium is any kind of contact with the tenants is good contact. Keeping informed of what's going on, keeping updated with the tenant if they're having a job issue, if they're having payments, getting out in front of that rather than 3 months down the road, looking at it and going, wait, they haven't paid rent in how long? And then going to the tenant and asking, see what's going on. And then most of the time you'll find out that you're just getting met with a blank wall. So from both perspective, tenant side too, I advise, all the tenant clients as well to be proactive with your landlord. If you know an issue is coming up, get in front of it, talk. And so that's a big part of the contact. But in addition to being updated on the laws, make sure you understand what county, what jurisdiction you're in, whether it's unincorporated King County versus City of Seattle. We see that issue a lot where you have a Seattle address and it turns out you're in an unincorporated King County. Be up to date on your address. Keep up to date on water bills, utilities, those kind of items that are going to ultimately be directly billed to the property owner. If those get behind, I've seen a lot of troubles with those, but those can be accounted for if you're proactive. And hopefully with everything going on and the amount of money that's supposed to be coming towards a lot of these programs, is that people will be able to find these resolutions and work with third parties that are coming up to help in these conditions. The big one here that I really want to press on also is the repayment plan sides of things. Entering into these conversations can be hard, and nobody wants to lower a rent or not be paid the full amount that they thought they were agreeing to with the tenant. However that may come up, but the big thing to understand here is that keeping in contact, going for the due is number one, but also coming up with an actual reasonable payment plan. This doesn't have to be a negotiation where you're forgiving the rent. There's creative ways to do this. There's creative ways to put the rent on later months, to amortize it over the remaining part of the lease. And if you can work with a tenant and you're on a good amicable basis on that front, I say exhaust that route, because it's just we're not in an environment where it's quick or efficient to remove somebody from your house. And then other than that, if you don't and you haven't, it is a good idea to engage with local counsel, especially within your area and the practice in this area, because I can't tell you how many times I've seen something come through with a notice that was sent, and it would have taken a 5-minute call to understand that notice was improper, and you're going to have to redo the process. So getting ahead of that and just make sure that you're watching out for that, and have somebody in your court, a good attorney that knows the ins and outs of it. And obviously our office is here to assist on that and help you on that front. And then on the don't side, I just want to really quickly touch on this. It goes without saying that this is a very frustrating situation, but there has to be a recognition that we have to work within the bounds of what's out there right now. And so getting into a contentious issue with a tenant and threatening items that in the reality of where the law is right now that aren't going to happen isn't going to do anything here. So the threats of eviction without working with the tenant, those kind of things, you just got to exhaust that amicable resolution. It's frustrating to hear. I know it's one of those things where we don't even know where the law is going, and we expect things to be continued and changed in the coming future. But just don't go with the knee-jerk reactions. Understand, evaluate, and figure out that the best resolution right now is going to be an amicable resolution.
And also, I just want to piggyback on the don't, that particular don't on like threatening actions. What we've seen in with threats, landlords' threats, or like even if we see a communication from our landlord, if the tenant perceives it as a threat and then they report it to the Seattle Office of Civil Rights or the Attorney General, we're seeing these government attorneys just jump on landlords, like we've never seen before. So that's why we're emphasizing don't threaten. While you might have been able to kind of get away with more, aggressive comments previously, it just isn't going to fly right now, and it's putting yourself at risk. So anyways, I just wanted to make sure that everybody was aware of that.
Yeah, just to piggyback on Hamilton right there, it's a very expensive process. Nobody wants to go through, whether from the tenant side or the landlord side, no one wants to go through a court process of eviction. It's normally when you get to that, you've exhausted everything, and what you're really looking for is possession of the property back. The monetary side of things is especially in this environment right now, is basically out the window there. And so it's almost akin to throwing good money at bad. So looking at the process, looking at a plan, looking at an agreement is always going to be the best route right now.
Thank you, Rob. And I think we all understand that government enforcement is something that's going to take a lot longer than whatever the issue is with your tenant. So if you do get a code enforcement or a notice of violation because of your actions, it's going to drag things out even longer. So moving on to some frequently asked questions. And we'll kind of fly through these because we've got the highest number of attendees at our webinar ever, and easily that means the highest number of questions asked already by people, and I'm sure there'll be more questions. So we'll try to move through these quickly so that we're sticking with one of the traditions of our webinar, which is not hitting the full hour. We try to be right there in that like 30 to 40 minute range, so you can get on with your lives, take some good information and move along. So the first one that we are seeing fairly frequently is that due to an emergency in the family, we're trying to sell our residential property, which is in Seattle and occupied by a tenant that is month to month. What should we do? Rob, you want to field that one?
Yeah, and this one is probably the most difficult one that you hear, because these are situations that no one wants to get into. And when you get into a situation with a tenant that just does not want to leave, especially in these situations where all the landlord or the owner is trying to do is actually get rid of the property. They're trying to sell it. There's a reason for that. There's a family emergency. There's just a need to be out of the market, and they don't want to be in that situation at all. So the best approach to this is right away. When you know this is coming up, get in front of it, talk to the tenant, be very upfront about what your plans are with the property so that they understand it from an emotional standpoint, make that connection, understand, and hopefully, fingers crossed, you guys can work out an agreement if it means ending the lease early so you can get the property on and figuring out what to do there. If you're unable to come to that agreement, there is the exception within the greater state of Washington right now, which is the 60-day under the bridge. Well, it was, now the bridge has taken over that, so it's out the window. But earlier in the pandemic, you had to provide the 60 days notice of intent to sell. That's no longer under the bridge, but in the city of Seattle, that's where it's been the biggest headache, because the only valid reason under the city of Seattle laws right now is for health and safety. And so it's really is having that upfront conversation and being very clear with the tenant. This has nothing to do with the tenant. This is a circumstance that's been created by family environments, family emergencies, and hopefully they understand that. But that's the best advice you can get there, is just be in constant contact with that tenant.
And we're still keeping in mind during that discussion, all the do's and don'ts that we just said. It can't be a threat. It can't be a threat of eviction or anything like that. This is just a discussion about the realities as they exist in your life. And there's no law prohibiting you from saying, here's what's going on. And if the tenant, has the ability to work with you, that would be great. The next one, we have a commercial tenant in Seattle that we allowed to pay half the rent for almost all of 2020. And they now owe a substantial amount. How are landlords handling this? Well, and I'll take this one on. The first thing that we try to do early and often with the advent of all things COVID was to get things in writing. So if you made an agreement like that, hey, we're going to reduce it, but here's how it's going to work. If you didn't do that, probably now's the time to get into that mode where things are in writing and there's a plan moving forward, one way or another. If per our earlier discussions, if you're going to go down that route, at some point, it seems likely that you're going to have to demonstrate that you at least made an effort to work with your tenant. But most importantly is getting it into a state that's in writing. We do have some collections actions where, there's at least a breach of contract claim out there. You're not going to evict, but it's out there. There are some rules in the city of Seattle against pursuing personal guarantees on small business owners. So I would, again, reach out to an attorney before you talk about any of this or threaten any of this. The key thing is trying to get this stuff in writing, because for a lot of our clients for the last year plus, they've allowed it to happen, but then they haven't come back and said, okay, here's what's going to happen next. And it's very difficult to look back a year and a half and say, okay, we did this. We didn't really say when it's got to be paid back. Now let's talk about it. Because for a lot of the commercial tenants, they just don't have the financial resources, and it's going to be tough for them to battle back. So try to jump on that earlier than later. Don't let it just sit there. The next one was, we have a residential tenant that's disturbing other tenants and or in breach of the terms of the lease, is not committing crimes. How do we keep from not breaching our leases with other tenants in the building? I'm going to let Rob or Hamilton take that on.
Yeah, and I can touch on this one. These are really tough situations because you see this a lot in Seattle, and there's no clairvoyant. It's not really just a clear, straightforward answer, because it's all going to depend on each circumstance coming out. But you're weighing, in a multifamily situation, an apartment complex situation, you're technically weighing the rights of the other tenants that are feeling, that they're not getting the quiet enjoyment of their property against a tenant who may be committing breaches of the lease, but do not raise to the threshold of an imminent hazard to the safety and health of other tenants. And when you're stuck in that predicament, it goes back to the contact with everyone and with the other tenants, and making sure they understand that there are constraints to the law right now. This is, in the past, you could issue a 10-day notice of violation for the lease rules or something of that nature. But when the eviction moratorium in Seattle especially came in, the 10 days went out the window. So what you're really looking at is the only thing that raises to the level of actually being able to remove a tenant is those imminent threats to health and safety violations. And I can provide some examples of what I've seen through the court. I can provide some that didn't raise to the threshold, which I was very confused by. And I can also get to some that did meet the criteria. But what you're looking for is documented evidence of either a crime being committed against another tenant, or a safety issue, whether it's, and the biggest thing the courts are looking for in evidence for this, if it has to go that route, unfortunately, are police reports and responses on the same, affidavits confirming what was going on. But the carrying weight is a lot of those is the police reports from what I've seen from the commissioners here, at least in King County.
On that too, that actually goes to our first kind of live question, relates to the experience with health and safety exception. And Rob, you hit on it like the nail on the head there, is that the biggest piece of advice that we can give all landlords is document. One, landlords cannot prevent assaults. They cannot prevent crimes from happening. If there is a crime, instruct your other tenants to call the police. The more evidence we have, the more reports we have, the more likely, or you're increasing the likelihood that we as your legal counsel can evict this tenant under the health and safety ordinance. So document it. have tenants testify to it. If they can take pictures, don't send stuff to the landlord all the time. They need to do their own job. If they're concerned about the safety of where they're living or what's happening in the building, they need to take ownership of it as much as the actual building owners, because the actual building owners are tied in what they can do, so many things. So I just want to say that the evidence is going to be like crucial in that regard.
Yeah, and you always want to get a police report, but it may not, even if it's not an emergency, there's a non-emergency line that can be called. There's a website, there's a way to get in and get a police report filed. So there are many options for making sure that documentation is being created. So I think that kind of touches off our first live question. The next one was, how is low income defined for rent increases, and how do we know if it is considered low income?
I can answer that question. So to qualify for low income housing programs in the city of Seattle, the household's income must not exceed 80% of the area's median income, specifically being like the area's median income. So depending on where you're at, it's going to be 80% of that. And so like if you have one in your household, one person in your household in the city of Seattle, just focusing on Seattle, that 80% of the area median income is going to be $63,000 a year. So it's actually a lot more than you think it would be, but that is 80% for low income in the city of Seattle. That's how you qualify for public housing. I would imagine that is how they are going to hold us accountable to it if there is low income. If you got anybody that's close to that threshold, be really careful. You're just gonna, if you don't want somebody on the edge and then you get called out because the area median income like increased in the last 6 months and you weren't aware of the latest spreadsheet that shows the median income going up. So just be very careful when you're talking about these notice periods and percentages and the calculations. It's very important to follow that and be timely with it.
I think that's sound advice or guidance on these issues. We're not giving legal advice here. We'll give our disclaimer later. Another question was, if you have a residential rental in Seattle, can you send a written notice of increase for 60 days out? If you send the notice before November 9th, 2021, rather than making the rental increase effective 180 days of notice when sending out after November 9th, 2021. And I think you kind of touched on this, Hamilton, earlier.
So we have some clients doing it, but there's the question of, while under the Seattle moratoria and the bridge, there's no rent increases that are allowed. So if you target 60 days out from November 9th, that goes to January 9th. That's not, the Seattle moratoria has not expired at that point. So I wouldn't recommend it. It's all if you're going to do that, I would say that there's a chance that you're asking for trouble there and that somebody's going to send a notice and then you're going to get, Seattle Office of Civil Rights or, King County Housing Justice Project, somebody reaching out to you saying, hey, this is a violation of the moratoria. Maybe it might be right. It might be fine, but, and depending on where your unit is, whether it's Seattle, outside of Seattle, but you just want to be very careful when you're sending out these notices for rent increase.
Couldn't agree more. And again, this is something where you want to check with your attorney about what ramifications might be there if you do this. And the goal for all of these, it's already a long process to evict someone, as Rob went through. You want to avoid the legal system if at all possible, be that litigation or whatever mandatory resolution process is in place. So anything on the edge, you're risking extending the time that you're dealing with this rather than reducing it. The next question is, if there is a month-to-month residential tenant who is not paying rent in Renton, so in King County, but not City of Seattle, is the best step to start with the ERPP form?
And I'll touch on this because this is such a new kind of adventure that everybody's going to go through. I would say, yes, start with it, because what you are showing is the good faith kind of resolution towards a repayment plan. And so if there's this guideline that we know is going to start filtering through the different counties and is going to be available, you might as well, if you're trying to really work with the tenant, you might as well use that as a resource. So I think it would be a good practice to do that, though it's not necessarily mandated within those counties right now until that's set up. It can show good faith, with the tenant that you're trying to go through the program, and if it does come in the future, he steps ahead.
Another question, and we appreciate your question. So thanks for participating. Is there a cannot evict during winter law in King County, or is it just the city of Seattle?
Well, that's kind of it's a funny question to ask, because what we're talking about is all of these laws are constantly evolving right now. And we don't know what's going to happen with the winter, if there's going to be an increase, if we're going to go back to emergency orders. So without being clairvoyant, there's not necessarily a cannot evict as it's being put in quote in King County. However, we don't know what the future is going to bring for the winter timeframe, and it could go back to a different program under emergency orders.
Then we've got a similar question tied to, outside of Seattle. So Pierce County, single family home, tenants not behind in rent, landlord would like to sell. What's the notice time?
Now that's a hard one to say just off the top of a head, because you're dealing with different jurisdictions. There's county, there's city, so there may be things generally out there. But when we were working under the moratorium before the bridge and everything, we have the 60-day statewide. And for better or for worse, I would just say if you're going to be belt and suspenders type situation, contacting the tenant, making sure they know, and if push comes to shove, send out as advanced notice as you can get that tenant. Don't require and don't think that you're going to send out a notice, and whether it be a 30-day notice or whatever it may be, that notice is your golden ticket, and the tenant will say, oh, I got this, I have to be out of the property, because that's not the reality of how any of this works. So if you're planning to sell a property and you get out that notice and you're entering into a contract with that in mind and kind of hoping that tenant will be out by that time frame, you're setting yourself up for a hard situation. So what you want to do is just get as much advance notice out there as you can, and work within the confines of whatever the current orders are going to be in place.
Keep in mind too, also, that there was originally the 60-day notice, which was then changed in June to a 90-day notice. So, or I should say, end of June. So the notice timeframes are evolving, and this is just an example of how fluid this area of law is. So, and that was a Washington state specific, not the city of Seattle. So that's why we're encouraging you to always, evaluate both the city, county, and state. So if you have specific questions, reach out to legal counsel. I see this next question about the ERP notice, step one, send step one and then wait 14 days, 0 response. It isn't that simple. You send the notice, you've got to submit it to the county, and then and this is just specific to King County. I want to be clear about that, because each county has their own eviction assistance programs. So you have to go to each county, but the one that I was talking about earlier was King County. So you submit it to them, you provide it to the tenant. You have to advise the dispute resolution center that you've done that. If there's no response, then you get your certificate. And after that point, then you can submit your 14-day notice. And if they do respond to participate, then submit for enrollment. That is going to be on the King County program to do that. So it's kind of outside of your control. Once they submit, it's outside of your control.
And then our final question, is there a distinction between a tenant who has actual hardship and financial issues as a result of COVID, and one that does not? And I think we can say that the eviction moratoria is just an outright prohibition on evictions of any nature. So that answers that. There was, I think, initially in Hamilton, and Rob can correct me on this, initially in the first round, right at the beginning, there was a discussion about if you were a business that had been impacted by COVID, but you weren't a small business, then the commercial landlord had to go through this analysis of whether you were impacted by COVID. But other than that, these evictions of moratoria have been a straight up prohibition on evictions.
I'll do. There is a defense in the city of Seattle that if you have to submit an affidavit to Housing Justice Project that says that you've been financially impacted by COVID. It is a defense in an eviction after the moratorium is over. So there is a distinction. The tenant is required to submit, again, this is city of Seattle specific, and that's why city of Seattle is very complicated, is that if they submit that affidavit, do they have to provide financial statements or bank statements or employment records? No, it is just a statement. There's all sorts of problems surrounding that, but it's just a statement. If that statement is submitted is a defense to the eviction.
Okay, so one final question. We have a single family house available for rent now. Is it worth the risk to find a tenant through a property management company now, or should we wait for something until COVID is over? And I think you're asking the $1 million question that we hope to have answered. Are we going to create a chilling effect by all of these rules prohibiting evictions? There's no way that any attorney on this at our firm can answer that question. It's a business decision as to whether you would rent to a residential tenant in the current climate, given all the rules. Obviously, we have plenty of clients that are working with the rules and working within the system and electing to continue to rent residentially. And we have plenty of clients that are electing to sell their single family residences and kind of move on. It's a business decision. So
I would agree with that. It's a business decision. If you are going to rent, however, if you do make that decision, make sure that you follow up with your screening criteria and you're doing all of the appropriate screening questions, minimum requirements for your tenants, and that you do your appropriate background and you get the right tenant that you want. So if you're going to do it, which, that's a business decision to Emon's point, but you want to make sure you're looking at the screening criteria and the minimum requirements for potential tenants into that unit before you go down that route.
yeah, and I guess I would also just add that just because COVID is over doesn't mean a lot of these regulations that are the most impactful for screening of tenants are going to go away. So those are the things that existed pre-COVID are going to exist post-COVID. So you need to be consulting with the local laws and a suitable and experienced attorney moving forward. So with that, we'd like to thank all of you for attending. We remind you that this is not legal advice. This is merely informational. You're advised to seek independent counsel as to your specific issues on all issues. We are having our next webinar on personal insurance. A lot of people ask us about what kind of property insurance they should be carrying for their primary residence, umbrella coverage, and issues for high net wealth and medium wealth individuals as to their personal insurance. We talk a lot about commercial insurance in other areas. We're going to have Rob Vanderschaft on, who is a insurance broker with a lot of experience, can answer a lot of questions and help us understand that. We appreciate you attending. And if you have further questions, our contact information is here. And again, we urge you to check out the websites we listed. Thanks again, Ann Davison, for joining us. Feel free to reach out to us. Our information is here, and this has been recorded. So if you'd like to forward this to your friends, family, colleagues, business partners for review, please do. An email will be coming to you and you'll be able to go to the link and have this as a resource. Thank you again, and we'll see you at our next webinar.